use this approach.
Good evening, everybody, and welcome to Behring Regional Center's webinar, the 2022 EB-5 Reform and Integrity Act. We're very excited to have everyone joining. I know we have a number of people still trickling in as we get going here. This, as a reminder, this will be recorded. So if you missed something or want to review it, certainly you'll have the chance to review it. There is a chat, and please send us your questions in your chats. It is set on private mode, so if you send a chat to everybody, only we're going to see it, and we'll be looking to respond to everybody throughout the presentation. And if we miss some questions, I can assure you that we will be following up after the webinar with everyone directly if we weren't able to get to it throughout the webinar.
Yeah, understood.
So just to jump into it, there's been a lot of exciting things happening in EB-5. But before we jump into today's conversation and an analysis of what has happened and what it all means, just a disclaimer that nothing that we're going through today should be misconstrued as legal or investment advice. We're here, it's a webinar, it's for information. If you're seeking legal or investment advice, you'll have to do that separately. So today's agenda, we're going to introduce the two teams that are in the webinar, the Behring team and the KLD team. We'll be talking about the key policy changes that have occurred in EB-5. What are those impacts on existing and new investors? There has been some changes that affect both groups. Winners and losers of the new bill, litigation updates, and future advocacy. And then, what do we view Behring's future in EB-5, and how are we looking at EB-5? And ultimately, we'll end with a Q&A. So just briefly, most of you on the webinar know something about Behring and our EB-5 experience. We have over $700 million in EB-5 projects since 2013. We have a perfect adjudication record on all projects and all investors. This is coming off the back of a 60-year history in real estate. Just in the last several years, we have over 1,200 units that were delivered solely with EB-5 or with the help of EB-5 capital, separately from our bigger and broader EB-5 or real estate platform. We've had 6 EB-5 funds since 2013. We have investors in 26 different countries. A few of our projects that have been successful in the past with successful exits include our MPC portfolio loan, the GRAD in San Jose, our Sacramento project. We currently have investors in our 1900 Broadway project, and we are taking more investors now with the reauthorized program. But this just gives you a sense of the types of projects that we do. We are focused on multifamily real estate primarily, with some mixed use in there. From a leadership perspective, Behring has been involved in not only policy and legislation through our partnership or our involvement in the Real Estate Roundtable and EB-5 Investor Coalition. We've been involved with litigation as well with our Behring Regional Center case that throughout the 2019 regulations and replaced them or sent them back, and then more recently with our case in 2021. We've been heavily involved in innovation within the EB-5 industry, whether it's shifting from hotels to real estate, being a major player in pushing partial capital commitments, taking investors with cryptocurrency, looking at different investment options, whether you're looking at a debt style investment all the way up to an equity investment that can be converted, and ultimately looking to continue to provide opportunities that are going to help our investors not only be successful from an immigration standpoint, but also from an investment perspective. So today, from the Behring side, we have Colin Behring, the CEO, myself, I run operations, and Peter Bibler, VP of Development, also an immigration attorney as well. From the KLD team, I'll let themselves introduce.
Is one of us supposed to say something?
I guess so. So
No,
we're KLD.
we
We're
all
based.
stand there in silence.
You want to go by order on the screen?
Go ahead, Nima. Go ahead.
So I'm Nimo Corpivara. I'm one of the partners here at KLD. I've been working with these two other gentlemen from KLD on your screen, as well as the Behring team for about a decade now. We weren't that old when we started. We're not that old now, but it certainly feels different after 10 years of EB-5, and then of course the Behring team has the added white hairs from litigation.
At least you guys have hair.
Okay, so my name is Neural Patel. Oh, sorry.
No,
Yeah,
go
ahead,
ahead.
Yeah, my name is Neural Patel. Recently joined the KLD team a couple of weeks ago, but I have been working with these guys for a while now. And like Nima said, especially with the Behring team, pre-COVID, we were traveling, India, Dubai, Peter, once or twice a month almost for the better part of a year and a half, just meeting with investors, showcasing projects and things like that.
Hey, I'm Fang. Not much to add other than what Noral and Nima said. You're going to hear a lot from us today, so you might as well get started on this, right?
Well, thanks,
Peter,
guys.
you want to head to the policy items?
Peter, you're on mute.
Yep, microphone.
All right. Can we hear me?
Hear you loud and clear.
All right, great. Well, there's as Fung and Neural just mentioned a second ago, that there's a lot to cover. So we'll be hearing from Nima and these gentlemen a lot at the roundtable, but we want to just give a high level overview of some of the key policy changes. So as of last week, Congress passed the omnibus bill, the annual government appropriations bill for 2022. And it includes DHS appropriations, and in particular, reauthorization of the EB-5 program. And we'll talk again a little bit about what reauthorization means, at least our recent lawsuit pertaining to this. But so it was passed. President Biden is expected to sign the bill either today or tomorrow. And then it will go into effect immediately. Some provisions go into effect immediately. Some provisions take effect in 60 days. This reform bill is years in the making, especially since 2015. I think we've seen extensions, maybe 26 or more extensions since 2015 alone. And I think it represents just some harsh political realities to muscle through EB-5 reform. And we'll talk about that a little bit in the roundtables. But suffice to say, the bill has been extended for 5 years. The program has been extended for 5 years. And as expected, the investment amounts have increased to $800,000 for TEA. TEA designation is stricter. It reflects some of the changes we saw in the 2019 EB-5 modernization rule, which limits designation by USCIS only. But it does allow for 2-year extensions on these validity periods for TEA. Significantly, for at least US-based investors, there's going to be concurrent filing options where you would be able to, if your visa is immediately available, you could apply for your adjustment of status simultaneously, or subsequently thereafter, you file your I-526 petition. And we'll talk about what that means and what implications that has on your timing, whether you get work authorization while you're waiting, effects on child age out considerations and so forth here shortly. New visa set-asides have been created for rural, 20%, 10% for high unemployment urban areas, and 2% for a new category called infrastructure projects. And these can carry over. Any unused visas can carry over. I know there's a lot of our current investors and existing investors from other projects in regional centers online. And the good news is that we do have grandfathering. So you're protected from any future lapses or expirations in the program. And so we should not see any future disruptions to your processing of your petitions and visa applications. And for new investors considering the EB-5 program, if you file anytime between now and September 30th, 2026, you will be grandfathered. That last year, for some reason, they have a gap where that last year in 2027, there's no grandfather protection, but we'll talk about what that means here shortly. One of the negative things that we've seen in this bill is that the requirement of administrative appeals. So many people in the past, if they had denials or other adverse decisions from USCIS, they would seek judicial review in the courts. This changes that. Now you must go through the administrative process before you can challenge or appeal a negative decision by USCIS, which could lengthen the time, lengthen the process for you. Job creations rules have changed. There's a cap on the number of indirect jobs, and that's one of been the, I think, the advantages of regional center investments versus direct EB-5 investments, is that it's easier to satisfy the job creation requirements for the green card by using economic models to prove indirect job creation. And you could create substantially more jobs in a construction project like ours than you would see in typical direct investment projects. Now that's capped at 90%, but even though direct is required, similar methodologies can still be used. And our current project continues to comply with these new requirements. Redeployment, we're going to see future regulations by USCIS to further define these parameters, but we do know that no passive investments are allowed, meaning that once your investment in your initial project has been completed, but you're not eligible yet for repayment, meaning you haven't had your green card, your conditional green card for 2 years, haven't filed your I-829 petition, then your funds need to be reinvested if that project is completed and repaid in the meantime. And in the past, there's been some question or some regional centers that would reinvest or redeploy those funds in passive investments such as municipal bonds. And this new law here states that no stocks or bonds are allowed or qualify as reinvestment opportunities for investors. But we'll go into more detail later. Priority date retention is back for innocent investors in case of termination of regional centers, fraud, and things of that nature, where you can retain your priority date and refile within 180 days. This is coming in the future, and of course, we'll see how it rolls out. But USCIS is required to perform a fee study in the next year and roll out new fees to achieve new targeted processing times, which could substantially improve processing time. So we'll wait to see what happens. But that could be anywhere from 90 to 240 days are these targets for processing of I-526, I-924, and I-829 petitions. And then we have the integrity measures. This includes agent registration. So agents, immigration agents, promoters, whether broker-dealers in the United States or abroad, must register with USCIS. So there will be a public registry. Agents will need to disclose to the investors the fees they receive from regional centers or new commercial entities or EB-5 projects, and assure that there are no bad actors, similar to some same requirements for regional centers and NCEs, meaning that they haven't been convicted of certain crimes, haven't been sanctioned or punished by financial regulatory agencies, and so forth. And we'll walk through here some of the key integrity measures, and that's been the heart of EB-5 reform since 2015. There's been a perception of lack of transparency, or even occasional instances of fraud in EB-5, and that certainly has happened. Bad cases make news. The majority of EB-5 has been a track record of success for projects and EB-5 investors alike. But nevertheless, many of these things are important and are good for the industry. And these include best practices in the industry, many of which Behring Regional Center has already engaged in practice since 2013. There will be the establishment of an integrity fund. These will be, it will be sponsored by fees. So new investors will need to pay an additional $1,000 when they're filing the I-526 petition. Regional centers will have to pay $10,000 to $20,000 every year to fund this integrity fund, so that DHS, USCIS could conduct its site visits of regional centers and the projects, and attend events and just kind of monitor compliance to increase the integrity of the program. RCs, regional centers, must file an exemplar petition before any investor can file an I-526 petition. These haven't been required in the past, although it has been the best practice of quality regional centers to get that so-called pre-approval by USCIS based on their review of the business plan and economic report and so forth. So here, approval will be binding on future I-526 petitions unless there's been some material change. And now it is codified that regional centers must notify USCIS of any significant changes to the regional center within a certain period of time. And regional centers have always had to provide annual statements, but the content of these reports are changing, with additional requirements and certification of compliance with due diligence, security measures, as well as EB-5 regulations. And as I mentioned, we are new commercial enterprises, any affiliated job creating entities. The EB-5 projects, the persons involved in these are going to be subject to criminal background checks, and be prohibited. Certain people would be prohibited actually from participating, owning, or being involved in these entities to try to increase the integrity of these organizations, these operators. And DHS has been equipped with more power to sanction or terminate and debar persons or entities for non-compliance. And again, finally, there's been actually, although these reflect best practices already in the industry, some of these regional centers or projects themselves are going to be required to have a fund administrator or commission annual audits on to increase capital controls or on the projects, and maintain capital and commingled accounts with other funds of the operators. And again, many of these things are things that Behring has already established and is engaged in. So we don't anticipate any disruption for existing investors, and a continued track record for new investors. Many of you may be aware that Behring Regional Center, we filed a lawsuit in December 2020. And at that time, we were challenging USCIS's authority to implement the 2019 modernization rule that totally disrupted the industry at that time, more than doubling the investment amounts. Applications dropped by 99% over the course of 2020. And we found that rule was unlawfully implemented, and we won in court. And that rule was vacated and we restored the investment amounts and the original TEA rules. But we knew after that result, we still knew that Congress intended to increase the investment amounts and make changes. But our goal was to have Congress do that and not go through DHS and to allow a little bit more public involvement, public negotiation and discussion for those rules. And that's what we're seeing here. And we'll talk about our involvement in the lobbying efforts, advocacy efforts in getting EB-5 reauthorization. And then last month, we filed a second lawsuit where we challenged USCIS's complete stoppage of the RC program after June 30th, 2021. We reviewed the statute. We, after close consideration and consultation with our attorneys, we found that actually the regional center program was intended to be permanent and not subject to these artificial deadlines and unnecessary rushes to beat these sunset dates. And we filed a lawsuit to challenge USCIS to restart the program. And the consequence was that this created a lot of pressure on Congress, and especially a few key senators, to break the deadlock, the gridlock that was that had occurred at late stage negotiations to finalize a deal. And at this point, we are determining whether we will voluntarily dismiss the suit without prejudice, meaning that if we see certain issues that arise when this law is implemented by USCIS, and we'll see how some of the rules and regulations are rolled out, then we may need to revive the lawsuit in case that occurs. But we found our experience, we don't engage in a lot of litigation, obviously, and we only do so if we have a sure shot of winning. And but we have found that litigation is sometimes a necessary tool to hold USCIS accountable. And it's sometimes a faster means to achieve change than the legislative process. And so we'll continue our advocacy efforts, and this includes these gentlemen from KLD, their advocacy efforts both on the policy front and the litigation front, as well as for investors as well. This includes a lot of the rules and regulations that need to be rolled out and how they implement this new law, seeking strategies to recover unused visas, or retrogression relief, which is a kind of a major gap in this bill. And as I mentioned, there's always maybe the potential need for court intervention. And this includes, on the investor side, the potential need for mandamus actions to ask the court to compel USCIS to do its job for you. And so if you're our panel of lawyers will be able to discuss further. But if you find that your applications have been pending for far too, it may still be appropriate for you to consider a mandamus action, and you could consult these attorneys to determine if that is in case the best choice for you. So with that, I'll shift it to Colin. And again, as you have questions, just feel free to submit them in the chat. And when we get to the end of this session of the Q&A, we'll be sure to address all of these.
And just as we're waiting for Colin to jump on, just one thing I want to call out. I mean, some of the questions just in the chat, I think would warrant be better handled in like a consultation or a follow-up. So if there's some specific source of funds questions that you have, or you have very, very specific considerations that are very unique to you, sometimes these will be best handled over a conversation where we can spend 20 minutes and dig into the details. So I want to just let everyone know that our team's available. We'll put up I think we just put a find a time box up there so you can schedule some time. We want to make sure that not only do we handle today's topic in as much detail as we can, talking about what just happened in the EB-5 industry, but that we can also handle your guys' questions as a follow-up if we can't get to it all today. And some of the questions, chat just doesn't warrant the importance of that conversation. And so do schedule some time with us. KLD, I'm sure, would like to talk with you guys as well and can give you a lawyer's perspective from a legal perspective on some of these questions as well. So reach out to them as well.
Some of you have been talking to us for months, so maybe send us some money before you send some more questions.
Yeah. So yeah, for everybody, we're going to get to some roundtable discussions talking about the details of what we've seen in the bill, how we got here, and kind of how this all played out. But for our next webinar after this one, we're also going to go into the future of EB-5, how things have changed, ways to embark on this new policy, and really our next projects and how they're being shaped and structured and ready for kind of EB-5 3.0 as we move forward. And yeah, there's a lot of things changing, but some things are the same. Our 1900 Broadway project is still a target employment area certified project location. And, previously with the old policy, I-924 approved, 526 is approved, investors approved. It's fully funded. It's under construction. 3 different investment options, which depending on your retrogression issues or your risk and return profile, you have an ability to customize how you're going about it. And now was codified in the new regs and this new law that was passed about unsecured loans being used as source of funds. And our partnership with the Unity lender that does loans for EB-5. And it is a qualified source of funds now. The John case essentially codified it. Cash is cash, loans work. And we'll talk about it more with our attorney friends here on how that works and how to get that papered up properly if that's a route that you want to end up going. But the Unity lender is an option for people that with that new $800,000 price, if it's too much or too high or financially, there's strategic reasons that you don't want to sell certain assets like a home, stocks, or other things that you'd incur some sort of tax event. Sometimes financing part of the investment makes more sense. So now this Unity lender option showed up in the bill, was named directly. It is okay to be used, whereas before it was a big dogfight between all the industry investors and USCIS, but that's been settled for good. Wanting to get into this roundtable and starting to discuss the prospect of really what's going on for existing investors versus new investors. So wanting to kind of open this up to the KLD team and everything else, just starting this off where the number one most important and most obvious item that everybody on the existing investor side is looking for, they are grandfathered. They are in it. Your process is essentially set in stone. There's no more lapse. Your torturous 8 months is over. It wasn't comfortable. It wasn't okay. We endured it and we somehow survived, but grandfathering is in. And that was a whole different battle to discuss the ups and downs of getting that into the bill. And there's a lot of people to thank for that. But going into the other details here, your previous policy is still in effect. You don't have to come up with the new money as an existing investor to make that $300,000 gap between TEAs and the old policy and the new. Your processing will resume. There's a couple of different items that pop up in the policy for new investors, which it's yet to be known if that's going to pop up for old investors, things like concurrent filing, going for the combo cards. We'll let the KLD team speak to that kind of stuff in a moment. And then the existing investors are going to get a bump in integrity measures, fraud protection, fund administration, and other things that are now dictated for regional centers going forward. So in discussion and in focus on the existing investors. Nima, why don't you just kick us off on what you think like the most significant achievements here on the existing investor side? Like, what do they have to cheer about? What is there any other risks that are popping up? What's your take for existing investors here?
It's definitely grandfathering. I think no one in this webinar, but there's been heavy advertising of 500,000, 3 to 5 years, you'll have your money back, and it's kind of been ingrained in investors of this expectation that no matter what happens, I'm going to get my money back in year 5. And that was used to the advantage of some regional centers, different projects, and that they were able to recycle the money, go into other projects that the investor didn't necessarily approve of. So I think it's really important, one, to remember the EB-5 program is not a 5-year program. The EB-5 program is a 2-year program plus processing times, right? So when we all started this, we were getting applications approved in 90 days, which means 2.5 years you would get to your A29 and you would be eligible under the regulations. With current processing times, it's at least 5 years to get to the A29, and that is further impacted with the regional center program terminating in June of 2021 and not coming back until Biden signs the bill tomorrow. So I think, if you follow the EB-5 news, there's always been this give and take in the EB-5 program, certain senators calling for reform, calling for expiration of the program, but it never actually happened. We all, outside of some lapses for a few days here and there, we just kept continuing, and I don't think anybody really thought the program was going to go away. And so, with this hiatus of the 8 months, you now have investors that are just going to have to wait even longer before they get to their A29. We have to figure out when USCIS is going to start processing cases again. Is it when the bill is signed tomorrow, or is it another 60 days? So far and away, the grandfathering is the most important. Now we know, regardless of what Congress decides to do, what USCIS action there is, your case as an investor is going to be processed no matter what, under the rules that were in place when you signed up, and you will not be impacted by the politics of the program.
Okay. Thank you, Nima. I think we can all agree that having all of the phone calls about grandfathering and potential lapses and everything else, we're all glad to say goodbye to any of that. And these now existing investors and any investors up until the 4th year of a 5-year policy will be grandfathered forever. Not sure why they carved out the last year of a 5-year program to X out any investors that show up in the last year, but that's neither here nor there. Looking forward here for the new investors, Fung, what's your take here on the new terms and like the new big bold bullet points, the 800Ks, minimum investments and going forward? Like, what do you think are the items that are the most pronounced for you?
I think one of the things that, certainly all these new integrity measures, although they can be kind of painful, is overall in balance, I think a plus for investors, right? You need more transparency with how the regional centers are spending your money. You should be getting your annual reports and everything else. There's certainly a lot more oversight of regional centers. So that should be a plus for the investors. But what really stood out to me when I was reading through the bill is that we always say that the project is extremely important in EB-5. The project is the one that creates your jobs. The project is the one that repays your money. But under this new EB-5 bill, I think investors really have to understand the regional center group that's in charge of sponsoring the project, right? Because there's just so many more requirements now. It effectively, I think, spells the end of like the smaller mom and pop regional centers or people without a team, unlike Behring, or you guys obviously do have that team, but without that kind of institutional experience, without that kind of expertise, without that full commitment to the EB-5 regional center program versus dabbling, I think it's important for every investor, every agent to really understand the regional center group behind like the projects now. So I think vetting of regional centers, due diligence on the regional centers, is a newly important like concept now. Yeah.
So, all agreed. we look at it too, as far as like what the workload looks like for us and, the changes that need to be put in and really kind of implemented before this 60-day switchover period that was stated within the bill. And it's a substantial change from the previous regulations, but for us in our back end and our fund administration and everything that we've already digitized essentially with our platform, all of our investors have seen it every single year, just having the digital platform with all your annual reports, all your documents. It really wasn't a big change for us, but we know some groups out there that are definitely feeling the pain of essentially having to rejigger their entire accounting and finance and back of house because previously it was a lot of Excel statements and a lot of hand-to-hand holding and sending of reports email by email. But this is a big change for some of the groups that weren't ready. Nero, from your perspective on the investor side, preparing documents or what you'd expect to see as far as the workload to file I-526 and take it forward, do you see big changes or is it pretty similar to the old bill? How do you feel about it?
Yeah, I think for the investors going forward, as long as you're picking the right team for you, the source of funds is essentially going to remain very similar. You just got to remember that you've got to have proper documents to prove your lawful source, whether it's a gift or a loan, unsecured loan, sale of property, whatever it is. You've still got to have proper documentation in the previous regulations and the regulations going forward. That much really isn't going to change. Now you just have to prove an extra 300,000, but that's where it comes down to.
What do you think about the? I know obviously there's some ambiguity and we have to wait to see how USCIS implements this, but this notion of fees now. I know historically USCIS required sourcing the lawful funds of the regional center's administrative fee, but now the language seems to be broadened to include any fees associated with the EB-5 investment. Do you have any preliminary thoughts about how USCIS might interpret that language?
Yeah, I think USCIS is definitely going to scrutinize any sort of payment coming from investors or being paid to the regional center, the project for EB-5 purposes. I would say almost everything has got to be disclosed. And I think they're going to start issuing, maybe RFEs if things do seem a little bit more on the vague side, or they feel like the admin fee or whatever it is not being disclosed. Before, you could probably get away with it. Now, I think they're really going to sort of clamp down on that.
Yeah, and to build off Narelle said, so part of it is, historically, even though it's not really in the regs or anything like that, UCS basically makes the investors source the admin fee. So this is an expansion of that. Just to give some background, I mean, like when we were reviewing the initial drafts and providing comments to it, right? One of the things we worried about was a possible fishing expedition. I mean, to what extent is USCIS going to go after and ask about like these fees, right? What about if I buy a plane ticket to go visit 1900 Broadway or another project that I'm visiting? What if I pay an agent to help me with source of funds if I'm overseas, right? The potential net is quite large if you think about it. So I think part of it is once we see USCIS policy and regulations, we'll certainly know a little bit more.
Yeah, we also have some huge concerns that one, we believe it's an overstep on USCIS side, trying to throw that wide net across every single expense that may or may not be tied to your due diligence process and going into it. But ultimately, the major problem is that it's not enforceable. For example, some of our equity investments, the administrative fee or a management fee is actually paid on an annual basis. So if that fee is coming in year 3, year 4, or year 5, and that's supposed to be part of your source of funds analysis and start to be put in there, but it's even yet to occur and hasn't been paid, but it's still in the documents, how are they ever going to actually conclude the source of funds review if they can't have any look at those fees? Just like any normal private equity investment would have management fees that are paid annually, not all up front. EB-5 is somewhat special in that you see this industry try to charge the administrative fee 100% at the I-526 filing. So ultimately, my personal expectation is that during this rulemaking process, they may gripe about trying to go after administrative fees or costs that are associated to the investment, but ultimately it's just not going to be enforceable or practical, because as soon as you ask them a question about, well, what about a 1% annual fee that is just due as it comes, they're not going to have an answer for that. They're not going to know. They're like, well, what do you mean they're not all paid up front? It's like, no, that's a market item. That's not a policy item. That's a market item. So, if you pay a CPA, an hour rate to just review something for you, is that going to have to go in there, or were you withholding a document? USCIS just bit off more than it can chew, and it doesn't quite understand the practicality of some of the things they're requesting. Also, in the bill, if you really read a lot of the fine print, you go over it, fine tooth comb, they really hit EB-5 with like a broad brush, as if every single project is the same. They think they can manage it. They think they can get their fingers around it, and that they can administer the program thinking every investment will be exactly identical, which is just not true. Obviously, historically, we saw a lot of EB-5 projects that look similar, debt-oriented, construction-based job creation, urban core, that was kind of market-based, but with longer retrogression times and longer backlogs or processing times and multiple types of investment cycles coming in and out of things like COVID, the types of investments will change significantly, and they won't all be the same. So USCIS is just going to have to learn to be flexible, and they're going to have to learn to adjust. And it's going to be interesting to see how they take that on, because, the policy was written by really two people, Senators Grassley and Leahy, that thought all EB-5 was exactly identical, and they were trying to attack it. So, it'll be interesting to see how that goes.
I would say to Colin's point as well, every one of us is an expert in our own field, right? So if you've amassed your 500,000 investment from being an engineer or an art dealer, you may not be familiar with investment structures and the way real estate companies operate. And so I think if you look at this EB-5 bill, Grassley and Leahy have been lamenting against a certain type of operator for years and years and years. The large real estate developers that are certainly taking advantage of the program. But if you look at the way a large real estate developer operates, they already operate with what the EB-5 bill is requesting, right? Third-party fund management, maybe registering your securities with the SEC, having a broker-dealer involved where you're notifying the fees, having construction drawdowns, CPAs preparing your documents. This is already happening, and this is a very, very high cost. That's why you can only see those level of developers do that. So USCIS is just now codified, right? Or the legislation has codified what everybody was already doing, but now just putting these regulations on everyone down the line. So when an investor sees something like, oh, agents can't get away with fees anymore. Okay, well, it says that in the law, but how do you actually report that to USCIS? Is it on a PPM? I mean, we were discussing today, what if you sign an agent after the documents were created? Are you supposed to email USCIS? Is USCIS now going to get 100,000, 200,000 emails every time there's a slight change from a regional center? So it goes back to, oh, well, this new law passed, now I can choose any project because they have to follow these rules. No, because we don't know how these rules are going to be implemented. You need to work with a team that has always been doing things correctly. Then you can feel safer about your investment.
We've had a lot of questions. We've had a lot of questions here about concurrent filing. Does it apply to new investors, or does it apply to existing investors as well as to new investors? When can they apply? If for existing investors, when can they apply? Does it mean that they can get the EAD and travel permit while the I-526 is still pending, or and other issues such as child age out? So can you comment on this new feature that's just for U.S. based EB-5 investors?
This was the subject of our group chat today. There's, again, a lot of gray area in this bill. When can you file concurrently? Is it only new investors versus old, as you said? Is it 60 days after the bill becomes enacted tomorrow? So we definitely need guidance from USCIS and Department of State. From our chats with the bill, you can't really make a two-track adjustment of status system, right? How can you only offer it to 800,000 investors, but not 500,000 investors? So our understanding is anybody that has a pending EB-5, you will be able to file your adjustment of status concurrently, right? So you will be able to file the 45 with your pending 526. What does that mean for pending investors? Does that mean your 45 is going to be processed faster? No. Your 45 is going to sit on a shelf until the 526 is approved. And then USCIS is going to send notice to the I-45 team, this person is eligible, and they'll take your case off the shelf. What it will mean, however, though, is some of the procedural steps will move faster for you. For example, your fingerprinting can be done as soon as you file the 45. You can apply for the EAD and advanced parole. And then the other question is going to follow is, do we get the Child Status Protection Act? Will our children remain locked in of age from the moment that we file the concurrent filing? Or will it be based on, is my priority date current at the time that I file the 485? And I'm going to let these two gentlemen answer it, because I think if you ask 10 attorneys will give you a slightly different answer.
I mean, the hopeful, optimistic answer is yes, right? But I mean, historically, they require that it is available. So maybe for once they throw us a bone. Maybe this is a good thing. But again, USC has 60 days. Hopefully, not 60 days to give us some clarity. But I know some of you have reached out already, wanting to prepare 485s just in case they hit this window when it opens. So hopefully, as we get some policy updates or some regs from USCIS, we'll know how to move. But in the meantime, we got to prepare.
Yeah, I think it's also important to note that it's not as if a switch has just been flipped at USCIS and they're just all of a sudden going to start processing everything that's already there. They have just as many questions as any of you do, and it's going to take them time to ramp up and answer those questions and implement all these new policies and rules. And that's not just at USCIS. At NBC, it's still going to take even longer. Each embassy around the world sort of operates on its own island, and they have their own rules and their own processes, and they need direction from USCIS, and then they need to look inwards at how they're going to operate, implement everything. They all have backlogs because of COVID. So we're still going to need some time. All these different agencies are going to need some time to actually get through everything that's been building up the past couple of years.
Yeah. To give you an example of that, like Charlie Oppenheim, the former head of the Department of State, was speaking with AILA's EB-5 committee, and even he admitted that, honestly, I don't even know how the Department of State's going to figure out like how to bifurcate this process, right? They need the 60 days just as much as anyone else to figure this out. So, I think there's going to be a lot of back and forth between the agencies.
Got it. Also looking forward, you guys deal with a lot of other regional centers besides us. When you look at these integrity measures, like on what percentage base do you think the regional centers that you have or seen or know, what percentage of them are really ready for this? As far as the integrity measures and swapping everything over to the new bill, how painful do you think that'll be industry wide?
I think we're a little bit different. Certainly, in our time in EB-5, we've either filed the most I-526 or the second most I-526 petitions, but we don't work with every single regional center. We're not open to taking every project that walks into the door. Certainly we're not financial advisors, but we want projects to have certain policies, certain operations in place, because we've been through this. We know a regional center that's trying to do this their first time. Maybe they don't have great record keeping. Maybe they really have an arm's length transaction or relationship with the developer. They're not going to be able to get documents. Something goes wrong. We can't answer the RFE, and it becomes an uncontrollable nightmare. So we really want to work with regional centers and projects we think are best in industry. So I think for the most part, for those players, they'll be able to do this. Are they going to be ready to go in 60 days? Not that I've seen, right? A lot of them don't have projects that are going to fit that exact TEA yet. They need to figure out a way to implement it, but I think they will. I think the other question though is, anyone that's done any business in the world, when there are additional layers of security and regulations put on you by the government, fees go up. Yeah. And it's always a question of who are they transferring those fees to? because very rarely do people go out inside their own pocket, right? So I think you're now looking at the fundamentals of the project. Is the project able to do this, or are now investors looking at much higher fees compared to what they previously did?
Yeah, no, and that'll be a question after this fee study passes and they find out what it takes to get to that 90-day target and that 180-day target, the 240-day targets, because processing times, in my opinion, is probably the best fraud detection or fraud prevention that you could have asked for, because you're taking the element of time away to speed everything up, where the investors are seeing progress and they're seeing milestones where they can ask the right questions. One of the worst situations for the last EB-5 history was, okay, file my I-526 and then go sit in the corner for 6 years. Like, just don't even check in because there's nothing to look at. But for them to be able to speed up processing times and to be able to speed up the process itself, the investors themselves will be much more engaged and able to see their projects in action, the sponsors at work, and be able to keep an eye on things. So, everybody that was on the fence, like call it the Grassley and Leahy crowd, and everybody that wanted to talk about, the integrity measures and protections, they really could have kind of started cleaning their own house first. Processing times, visa numbers, not having the retrogression stuff. There were so many things that would have cleaned up the industry to make an environment where bad actors could not perform. Bad actors could not do what they're doing if they had fixed these items. Unfortunately, with this bill, we didn't see any direct elements to address backlog numbers or visa numbers. And processing times have targets. That was a major win for them to even admit that they'd like to go after a 90-day turnaround or 180-day turnaround for projects. But the program itself having an expiration date of 5 years, how do you guys feel about that? The investment process itself and investments having a life cycle of at least 5 years going start to finish. How does that make you feel, just knowing that this is 5 years with kind of a fake deadline of 4 years for grandfathering?
I mean, it's like they're drawing a number out of a hat, right? I mean, if you just go by the processing times listed on their own website, they're going to have these investors for 7 years, 8 years. So I don't know what the intention is. I don't know why you're going to go to the effort of doing a fee study if you have 15 months to, come up with a solution, and then the program's going to expire 3.5 years after that. What's the point of doing a fee study? I think, Colin, to your point, I think I've said this many times, I think 90% of the problem with the EB-5 program is processing times. And, they may put in this bill fee study, we're going to get processing times down, but USCIS is not funded by the federal government. It is funded in most visa categories by filing fees. Filing fees are not static. So if you tell me that I need an I-526 filing fee of $5,000 to get processing times down to 6 months, well, it's $5,000 at what level of investors? If we're doing 2,000 I-526s a year, maybe it works at 5,000. But if we're doing 1,000 526s a year, maybe they need 10,000. So, as part of this spending bill, the omnibus, USCIS had asked for 1.5 billion in federal funding to be able to resolve their backlogs. They did not get 1.5 billion. They got 275 million. Right? So they didn't even get a quarter of what they were asking for. So, new investors and current investors are tied together like this, because unless new investors are coming in, there is no money to process these cases. So for anybody that's coming close to the conditional period or the 829 5 years from now, we have an open question of where's the funding coming in to be able to process these investors in some sort of expected and reasonable timeline.
Makes sense. Moving on to a next topic, actually. So, I mean, is there anything else to say, for the existing versus new investors? Are there any conflicts between the two? Do we see anything in the bill that is concerning that, should be brought up? Or is there anything that plays really well? Is it like, besides the things we've talked about, what really stood out? Anybody have anything on that front? Okay. I mean, we've hit a lot of these topics already, so maybe we'll just go to the next.
And a topic that would be good to hit on just to bring clarity around is the visa carve-outs. I know that there's been questions coming in
That's right.
that there's these 20% and 10% visa carve-outs, and is that for only new investors? How is that going to play out? Are those going to go to the backlogs first, and then once the backlogs cleared out, start to get applied to future investors? Because I think as of the most recent report I saw, there's 13,000 or so like backlogged I-526s that haven't been processed. So, and then you have a number of visas that haven't been processed beyond that as well. So how are you guys looking at the visa carve-outs affecting, backlogged visas versus new investors going forward?
Yeah, another interesting question that we were discussing today. From best estimate, there's about 19,000 unused visas available for the EB-5 program. How do you implement set-asides that won't take effect for another 60 days, and anybody filing for a set-aside visa may be 2 years away from accepting one of those visas? So I think, and Feng said, we need to wait for clarification from NVC. I think the idea would be those 19,000 visas get immediately distributed to anyone in queue. And then starting, October 1 or October 1 of 2023, you would start seeing these set-aside visas for rural and infrastructure, just because I-526 processing time. I think it would be quite unfair and prejudicial to any pending investors to get the 19,000 available visas divided by 30%, especially when there are no incoming, visa applications under those new rules. But I think, the other question would be were there rural projects already in the pipeline?
Yeah.
And would they be able to benefit from this carve out? Infrastructure needs to be designated by the head of USCIS, so you wouldn't have to compete with any infrastructure projects. But I think that's an open question.
Yeah, and I did put up a poll, guys, that just asked the question of would you invest in a rural area if there was the promise of a set aside, and or it may or may not come faster? It's kind of important to us to understand how people are looking at this, because when we look at the new bill and they talk about trying to create things for rural and trying to create special set-asides, call it target employment areas versus conventional or rural investment. The thing that's concerning to me as a sponsor or developer, and even if I really wanted to identify a project that was considered in a rural area, you still have to go through the 924 first, because it's going to be in a rural area that you probably didn't have jurisdiction for or coverage in your geographies. Then to go get an investor I-526 and have that process. So a 924 plus an I-526, getting you to maybe a year, 2 years deep, and then filing the first investors. And then 2 years later, your grandfathering runs out. So do you guys see a significant hurdle or a difficulty if a new regional center needs to get filed and start today in this environment? How feasible or how much traction do you think that's going to get? Because with rural, that was the whole argument about Grassley and Leahy's positions and trying to shove this bill into, the hopper. It was the idea that they would get rural and integrity measures, and will they actually get more traction with rural from what you guys have seen?
Yeah, I mean, I would say not all high tides raise all boats. If I was interested in getting in the regional center business, not under these new regulations, I would not. The charges that they want to institute on a successful regional center being 20,000, in addition to the 924A, in addition to the reporting requirements, in addition to the site visits, I don't see what the upside is in being able to sell rural projects. Maybe there would be a demand, especially from backlog countries, China or Vietnam, to try to bypass their backlog in going through a rural project. But to your point, Colin, if it's going to be 2.5 years just to get your project approved, and you need to have a TEA letter along with your project approval, and your TEA letter is valid for 2 years, what happens if your project is no longer rural and you just spent $150,000 in getting your regional center?
Yeah, it's funny because there's always this talk about like we have to take care of the rural areas and we have to push investor money into the rural areas, and they basically did everything they could to make it as hard as possible to have a project in the rural area. These are things that they probably have to deal with on a state and local level with different financial incentives and everything else. It's not like something you just write through like legislation, and then these projects might actually like pop up. So I think it'd be interesting to play out, but I think the fact that you need a new regional center, the fact that you need to have all this in place, it's like they're making it as hard as possible for these new regional centers to pop up. So it'd be interesting to see how it plays out.
They pound the ground all the time that the US should be a free market with very little government interference. But as soon as rural doesn't get investors, then all of a sudden it's a ton of government, interference with regulations that I don't think even help rural.
Yeah.
Understood.
And, direct investments are basically done. We didn't touch on that, but it's going to be almost impossible to do a direct investment. So even if you had, a true rural direct investment project, it's going to be impossible to get off the ground.
Yeah, I think that was the next topic, Colin, is kind of the winners and losers to the integrity bill, or what improvements or major gaps in this integrity bill. And certainly one of the listed here, of course, was direct projects versus regional center projects. And Nima, I think you just touched on it, that there are severe limitations for future direct projects now. Especially with the pooled investment approach, where any pooled investments now are limited to those administered by regional centers. But we'll talk about some other how you want to frame this, winners or losers to this program, or major gaps or deficiencies. We've had some questions about child age out risks and freezing of child age out, or what kind of protections exist now, and what gaps are there in this current bill?
So, currently, when you file an I-526, your child's age is frozen, at least until the I-526 has been approved. What exists in the new regulation that didn't exist before, is if you're in the conditional permanent resident status and you're impacted by a fraudulent project or whatever, and you have to file a new I-526, then if your child, he or she is over the age of 21 but remains unmarried, then they can be included on a new I-526 petition. And I think that's one of the big takeaways, especially with the child age out and the biggest difference there.
I honestly do feel that was one of the biggest misses from the integrity measures, where to no fault of your own that a child ages out, and it's retrogression, it's backlogs, or just normal processing time. Even if you didn't have retrogression, like your child could age out because USCIS, for whatever reason, didn't respond to a certain document or send a certain document the way it needed to be. And one way to have added integrity there is, if it's not your fault for aging out, that they easily could have froze your age, easily could have done it. And why they didn't address it directly, it's just one of those things where you kind of wonder where, the intent of the bill, like, do they really want to help the EB-5 industry create jobs and invest and everybody get what they wanted? Or was it just really a missed opportunity for us to have improved the industry and the investors and the effect of the program significantly? But with concurrent filing, it looked like there was kind of a side door to address this issue. So if you're able to do the concurrent filing and you're potentially able to lock in the ages and you're able to achieve it without it being expressed directly in the bill, is that the opportunity and kind of the silver lining in this, where that side door was open to try and make that happen?
If I mean, we can only hope, right, through interpretation, through policy, that they kind of take that pragmatic, kind of like more investor-friendly approach, really. Especially because you look at these studies they're commissioning now, if they really are intending on basically processing all applications within 240 days, well, I mean, the one plus of long processing times, which generally speaking, there's no plus, but at least your age is like frozen, it's locked in. Now if it gets approved in 240 days, now what, right? Kind of scary, kind of scary.
Yeah, I think it's a huge miss. And Colin and I, you have discussed this many times. Are they trying to bring back an effective and attractive program, or are they just trying to give us a program so they can stop the lawsuits? So the way that we look at it is, U.S. is not the only country where you can invest in. At $1 million, you can go to many other countries and receive their version of a green card or even a passport, and you don't have to go through child age out issues, you don't have to go through source of funds issues, you don't have to go through endless processing timelines, right? So I think that the easy thing to do would be, if your son or daughter was under 21 and unmarried when you filed the 526, they're always a child. But instead they do this really complicated Child Status Protection Act, which involves you doing math based on processing times, accounting when the visa became available. And it causes so much confusion that, there's multiple websites dedicated to it. I think it's a huge miss. And, if the idea was always to get entrepreneurs to come to the US and start businesses, well, again, when I started in this program 10 years ago, processing times were 20 days, 3 months max. So any individual that wanted to come to the US they could start their own business, create American jobs, and be really proud of what they were doing through their investment. Instead, processing times have ballooned out of control. Visa processing times have gone even longer. And USCIS added these subtle adjudicative standards called shovel ready, meaning if you want to submit a project, you have to be ready to go. You have to have leases, you have to have office furniture, your marketing materials. You need to be an operating business. Well, if I can't get into the US for 3.5 years, how can I meet this USCIS standard under the direct investment rules? Well, you can't. So now you're forcing us all to file through regional center applications, right? But then now you have child aid out issues and all these other problems that are coming as a result of processing times and then just not addressing visas, right? If you're making someone invest $1 million in the US, why do they even have a backlog for their visa category? So I think this is more of the government was getting really tired of Colin suing them every 3 weeks. And they said the best way to appease this and stop this is, let's bring back an EB-5 program that doesn't really work. And to any investor that's reading this, they probably think we're helping them by putting in all these security measures. Please read over the part that says we're removing judicial review from the EB-5 program.
So what does that mean for everybody? Like, because that's a lot of lexicon and acronyms and everything else. Like, let's clearly lay out what government threw at us there.
Well, being complicated is how we get the follow-ups. That's how we gauge and get more clients. Noel is our king when it comes to the lawsuit. So he would be better at explaining.
Yeah, I mean, we file. I don't know how many WOMs we've filed now over the past year, but I think it's got to be at least 20 to 30. And it is the best way to at least hold USCIS accountable towards their processing times. We filed WOMs at every single stage, at the I-526 stage. We filed it at the AOS stage, even if it's just for the AP-EAD combo card. And we've even done it for 829s that have been pending for about 12 months and managed to get those approved. We do keep an eye, a lot of people say, well, USCIS processing on the website, they say 60 to 72 months or whatever it is. And to be honest, it's kind of BS. Just because USCIS posts whatever they feel like on their website doesn't mean that they can't be held accountable for how long they should actually be taking. And so these are really good mechanisms that we use. We encourage our clients to use, and they'll come to us as well to really get USCIS to process their case timely. And that can also sometimes help for child age out, especially when you feel like a child is going to age out or may have that issue. It can definitely help for that as well.
Nero, do you have I know every case is different and it differs at each stage, but at least for, let's say, the I-526 stage, is there a general guideline as to when a person might consider a mandamus action? Like how many months or years they've been waiting?
Yeah, typically you want to build up a record, right? And you can start to build that up around the 18 to 20 to 24 month mark. And that's typically when, if we haven't seen any movement, we will file a WOM at that time. And in terms of building up a record, we like to see, that they've made service requests. They may have even reached out to the local congressperson to assist. And we put this into a complaint, sometimes 20, 30 pages long, showing USCIS. This also goes back to the fees, how they collect all these fees, but how the processing time keep getting slower, but they're still making a lot of money. And we put that into a complaint and we file that. And so you typically want to look around that 24-month mark, but it's a sliding scale.
And what about these, these 7-8 months lost in the, as this so-called sunset date since July? Is that time accrued that you could use as part of your argument, or part of that time?
Maybe. I think it's definitely worth looking into. It really depends on what sort of movement we see within the next few months. I think when it comes up for USCIS, what sort of what they're implementing based on these new regulations. And I feel like if we do want to be aggressive, we should be able to use that time as lost time.
And we've had a couple of questions. Can folks still consider mandamus action even with this new provision about requiring exhaustion of administrative remedies?
Yeah, absolutely. They definitely can. And I think, I just saw one of the comments that, since we had to withdraw old writ, a lot of our clients, we filed a mandamus action and then we had to stay the action because of the sunset date. And a lot of them asked us, what about that? Well, just so you know, now that the program is being reauthorized within, I think, 10 days, a lot of us will have to get in touch with AUSAs to file a joint status report, notifying the court that the program has been reauthorized. And my guess is that after conversations with the AUSAs and they've received some sort of instruction from the government attorneys, we'll hopefully see some movement within 60 days. I think they're definitely going to start asking for 30 to 60-day extensions, but I don't think a federal judge, especially out of California, is going to allow for anything more than 60 days.
And just one more question for investors on WOMs here. When you do file, whether it's by settlement or court decision, generally, how soon do you see a decision or an action by USCIS after that settlement or decision by the court?
Yeah, so we're very aggressive when we do file our WOMs, and 100% of our WOMs that have had a decision, it's all come through a settlement. That means that none of our clients have ever had to actually sit in front of a judge, go to court. We haven't had to go to hearings. We've just been working with the AUSAs to put pressure on USCIS. The quickest we got one approved, I think, was about a week. The longest one has taken is about 120 days. So that's sort of the time frame that I like to give.
Gotcha. Thank you.
Yeah, so we're going to open this up for Q&A. So anybody that has direct questions and would like the panel to take a look at it, please use that comment section in the chat and throw stuff in there. And we'd be happy to address everything that we humanly possibly can. But again, like I know a lot of these things feel really detailed and they feel like there's a lot of minutia to it and scary if you don't quite understand it right away. But again, that also kind of proves why groups like ours have value, and then also why we actually do the things we do with our projects, and specifically things like teeing up EB-5 ready investments like 1900 Broadway, where we have done the legwork ahead of time. 924 project and exemplars are approved, investors approved, they're fully funded, it's under construction, completion guarantees and other protections and terms across the board, institutional style investments. Regional centers exist to mitigate risk. It was supposed to make the process easier. It was supposed to get better quality deals, larger scale, more job creation, and more investment in the United States. That was our purpose and why we were created in 1992, just 2 years after the program was created in general, and then why it proliferated after the financial crisis and coming into today. We've put $40 billion into the economy. So it is our job as a regional center, as well as with the attorneys, and especially these guys at KLD, who I've been working with since inception, all the way back in 2012, 2013. And our entire mission in life is to make EB-5 easier and more palatable for everybody else. So even if you're not quite following every single little piece or term or everything else, I can tell you we live and breathe this every day, and we're tracking it down all the way until the job is done. So, again, this is what we do day in and day out. Besides building buildings and getting them operated, EB-5 is our daily conversation. So looks like we're starting to get some more chatter here. So let's take a look. Anybody see a question they want to yank at?
I saw someone said
So the
something about
unsecured loan conversation.
Well, I saw someone say something about the 10% visa set aside. I guess we didn't touch on that. The 10% visa set aside would be for infrastructure projects. Infrastructure projects are deemed so not by us as practitioners or Colin as the regional center, but it will be deemed so by the Secretary of USCIS. We don't know exactly what that means yet. Our assumption would be P3 projects, public-private partnerships, but the legislation says that the government entity needs to be the JCE, the Job Creating Enterprise. So I think until we get word out of USCIS, we're not going to be exactly sure what qualifies for this 10% set aside.
Any thoughts as well, Nima, on the secretary's special power to just randomly change TEAs?
Yeah, that's amazing as well. I always thought of, why do you need a state letter for a TEA? I think if you show the math, it works, give it to us, right? So I would think that when we're submitting these applications now and we're looking at TA regulations, so we call it, I think you called it the donut, I call it the egg yolk, where the TEA is the census tract you're in and then one next to it, right? In any direction. So, if you look at some of these like rural maps, a lot of this has not been designated yet, right? They don't have an exact census tract there. They may not even have a county name yet. So the way I see it is I think you're going to start seeing some people going to USCIS and saying, the math is almost there. We could move the building a few hundred feet over and qualify. We're in a rural area. There's nothing around us. Like, don't make us do that. Just give it to us. I think you could also see some pressure from public-private partnerships in the interest of the United States that are going to say, hey, you need to give an expedite on this. I think that's what they're angling for.
Makes sense. The unsecured loan tactics, looking at source of funds and the use of unsecured loans and that as a strategy, do you guys have general guidance on the best practices on making that work?
Yeah, I think, the unsecured loan, specifically to what you're doing as the unity lender, I think the responsibility is on the lender, not the investor. There's a famous case in USCIS, Zhang versus USCIS, where a court held USCIS has gone overboard in requesting source of funds from individuals, companies, lenders that are giving the investment amount to the investor. They have no authority or standing to question those documents. They can only inspect the relationship between the investor and the new commercial enterprise, right? So when the investor makes the 500,000, that's what they can look at. I think and Colin, you and I have spoken about this. If you look at the new legislation, they talk about, loans, unsecured loans being from a bank, and they don't define bank. And, if you look at the RFEs request for evidence that we've received over the years, anytime there's a loan from a friend, family member, a non-recognized bank, always the question that comes back from USCIS is why? Why is the person giving you 500,000? So I think what we've always done to get ahead of these RFEs is get us a letter. If it's an aunt, an uncle, a friend, get us a letter that says, why are they doing this? This is my best friend. This is my love of my life. This is my favorite niece. I hate all my other brothers, but this one brother I like. And it would be my dream for them to come and move next to me in the United States. And I'm going to give whatever it is, whatever amount of money it takes to get them there, right? I think for Unity Lender, it's a different question. Why would a lender make a unsecured loan into 1900 Broadway? And I think we answer that through due diligence. Investors always ask us, did you do due diligence on this project? Did you do due diligence on that? So I think Unity Lender would say, well, we've done a due diligence on 1900. We have no doubt that it's going to be successful. We have no doubt that the investor is going to pay us back. And that's why we're so interested in doing this. And, I have no idea what ground USCIS could stand on to deny those applications. I could tell the people that are still listening, the Unity Lender idea, I think, Colin, was like a year ago you had this idea. And, we shopped it to some other immigration attorneys and they all said no. Fast forward in time, everyone's doing it now, and now they're calling and trying to figure out, how is Unity doing it? How is the Behring team able to utilize it? So I think this is going to move forward. You're going to see a lot of projects offering this, but the way you actually package those documents to USCIS are going to be highly, highly critical.
I agree with Nima. And I think part of it as we move forward, right? And we have these investors in countries with currency restrictions and transfer rules and everything else, be it China, Vietnam, or India, really, this becomes a major part of their source of funds, right? If you have problems documenting your source of funds, you have problems transferring your money, this might be one of the few viable ways that you use in order to fund your EB-5 case. So I expect, this is going to be a great idea, but we're people trying to copy this idea.
Yeah, so I just added another poll, and part of the Unity Lender, and actually its primary purpose was actually a strategic tool for investors to be able to financially plan their EB-5 a lot smarter than just having a fire sale of everything they own, liquidating everything, and dumping it into EB-5. Because if you had profit on a property, stocks, or anything else, you're going to be subject to tax. And some individuals, especially, some of our lovely tech investors and people that had RSUs and options that have significant profits on them, they were going to be subject to quite a bit in taxes. And then being able to plan around the end of a tax year, being able to finance the investment instead of liquidating the assets in a forced sale for an event that may or may not take place in the next 12, 15 months or whatever it would have been back in the day. Hopefully these processing times come down to 90 to 180 days. But if you had to sell in the wrong tax year, it could have cost you tens of thousands, if not hundreds of thousands of dollars in taxes. So given that, one of the strategic uses of the Unity Lender is to help you tax plan, like taking margin accounts and or home equity lines of credit. Some people were able to do that against properties and pull the funds and do it without having to exit a property that may or may not have had 100% appreciation. So in this poll, we're seeing 79% of respondents had to sell investments, whether it's stocks or property or anything else like that. That means that if there were significant taxes to be paid, the EB-5 investment not only maybe didn't make a huge return on investment, but it cost you a ton of money in taxes. So trying to add more tools to the toolbox, trying to make EB-5 more palatable and more in reach for everybody, that's essentially what we're after here, trying to add these tools to a toolbox. So, and in the regs and previously, cash is cash. And to explore that and really chase it down means a lot to our investors, and it means a lot to us to really explore and find out what EB-5 is capable of and what it's not. And thankfully, we have the guidance of guys like KLD to actually vet this stuff out and and find out if it really works. And as we showed earlier on the innovation slides and all the things we've been able to accomplish over the last 10 years, we routinely have been able to put people in positions to do better on their EB-5. Partial capital commitments, same thing. As the price goes up at 800,000 and there's more taxes and more investments that have to be sold to make that 800,000, partial commitments and partial payments become even more important. However, we did see some language change on the partial capital commitments too, where it did get a little bit more descriptive. Nima or anybody else from the KLD team, it was pretty much written that you needed to have unrestricted access to all dollars. So when we're talking about gifts or other financing and things, what is your advice there for people that are preparing source of funds and they may or may not have it all in their own name and they're talking about gifts or they're talking about some other financing? What are you guys recommending there?
Yeah, and Fung, correct me if I'm wrong. I think that when they actually refer to that, again, when I look at this legislation, this isn't, in my mind, breaking new ground. A lot of it is taking adjudicative standards that USCIS was already doing and putting it into law. So when I see unrestricted, there was a time, especially when we had a number of investors from mainland China, that when they would get a loan, the loan would have a specific description of the purpose of the money. And USCIS started sending RFEs and then notices of intent to deny, saying, well, you're actually not able to use the money for this purpose. You have a restricted purpose of this money. It was to remodel your home. It was to purchase something else. And because of that, we're not going to allow you to use this as part of your investment, and we're not going to approve the application. And I think that was a big war with USCIS, and eventually, everything was getting approved without RFEs, but I think that's what they're trying to go back to.
Yeah, that's exactly right, I think. And this is the reason why when we work with people and everything else, typically we want to see your loan documents, we want to see your mortgage agreement, we want to see what's actually written in there. Some attorneys, you just look at it and go, well, look, you got a loan from your house, you got a HELOC, it should be okay. Turns out UCS or someone over there is reading it pretty closely, right? Sometimes there's a specific carve out, a restriction of using it to buy securities. EB-5 is a security, right? So some investors in the US who are taking a second mortgage or getting a HELOC to use for EB-5, it turns out that that's the kind of stuff that causes problems. So that's what we're on the lookout for.
There's one other thing they snuck in there, and I hope I'm not jumping the gun on you, Colin. Under the regulations, you never had to be fully invested until the 829 was filed. Now, USCIS, though, would not approve your application unless you were fully invested. So we kind of ran into this chicken and egg situation where Behring may give you 12 months to fully fund, but if by some miracle of God, your application was processed in 10 months and you had not been fully invested, you were going to receive a request for evidence or a notice of intent to deny showing that you were funded. So, you would have 30 to 90 days to get that funding together. The regulations have now been updated to say you must be fully funded by the time your 526 is processed. So for anyone filing at 800,000, we're not expecting processing times to speed up in the near future. But if they get to a point where they're processing maximum 6 months, what does that mean? What's going to be the average processing time if 6 months is the max? Are we going to start seeing 90-day processing times? So you're no longer going to have this ability to stagger your funding. And then again, it's at a much higher level.
Understood.
So,
just to make that completely clear, by regulation, you didn't have to be fully invested until the I-829. Are we saying that is completely out, even though like USCIS in practice wanted to see all the money at 526?
It's out.
It's out.
526 will not be approved unless you're fully funded.
Okay. Well, very clear. No ambiguity.
No ambiguity. So now it's just a game of processing times.
Yeah, and just to add to that, a lot of those who have partially sort of funded and are waiting for the I-526 to be approved and they're asked about concurrent filing, just know that you can submit a concurrent filing, but your I-45 is not going to be approved until your I-526 is approved. And like Nima said, you need to be fully funded in order to get your I-526 approved. So for those of you still waiting to fund, it's in your best interest to fund sooner rather than later.
Yeah, just taking a look at the other chats here to try and pull questions.
You know, at Romaine, you know, I think that was popular belief when with first COVID and, you know, then the regional center projects going away, that we would see much faster processing times. But again, it doesn't work like that. USCIS is fee-based. So if they are not getting continuous fees from new applications, the number of adjudicators at IPO, the Immigrant Processing Office, goes down. Application times go up. So the saving grace would be now that we have these mandatory processing times, but you know, still we're a year to 15 months away from seeing what those mandatory processing times would look like.
Yeah, understood. So part of the other discussion is like looking toward the future here. When we're talking about future advocacy and things like that, you know, you guys were probably more engaged in like rulemaking or comment periods. Like, how much does the industry, whether it's investors or RCs, how much do we have an opportunity to try and influence or participate in this policy manual that's going to come out for EB-5 going forward? Like, is there a way for us to voice concerns or help as far as trying to identify, you know, conflicts or ambiguities? How does that process work for any of us?
I mean, typically what they've done in the past, right, and we can only hope that they do this right now under IPO's new leadership, they usually will have a stakeholder conference. I mean, it wasn't too long ago that had regular stakeholder conferences with everybody in the industry, you know, and we go in and kind of like tell them what the problem issues are. They kind of give us new policy. It's a more like, you know, it's not combative. It's more like both sides are working together to try to figure out a solution. You know, all the questions, all the gray areas that we're discussing right now, there's just no way USCIS and DOS wouldn't be dealing with the same issues, right? It would make more sense for them to talk to both the investor groups and the stakeholders in the industry to kind of see like how in actual practice, whether this is whether this is practical, whether it's pragmatic. Otherwise, you can throw out rules out there, but if they're not enforceable, they're not enforceable. So I would expect some sort of like, I would hope actually that there's going to be an open dialogue like that.
Yeah. Okay. So, you know, this will be last call here for any burning questions from all of our viewers. You know, we still have 120 odd people that are here with us. So, you know, this would be the chance. You've got 3 of the top attorneys and an entire development team here to help. So if you have any questions, this would be the time to do it. But again, today was more about policy, just talking about the status of our existing investors and the status of investors to come, things to watch out for. But I guess for the guys at KLD, you know, if you were to leave everybody, you know, each of you with one parting thought here on, you know, the EB-5 world going forward, you know, what would you say? And then like, give us one prediction of how the next 5 years goes.
I'll happily go first. I know it sounds so rosy when I speak about the EB-5 program, but I think, you know, if your intention is, I want to be a permanent resident or citizen of the United States, there's 3 ways to do it, right? You go through an employer, you make an investment, or you marry a U.S. citizen. For those of you that are already married, I don't know if that's an option, but, you know, EB-5 is still the fastest way. And all it requires is your money, right? It does not require your time. It does not it does not require your hard work. You don't have to go sit into meetings and be a part of the construction team. It's a fully passive investment whereby you can live your life. And when the application is ready, you come into the US. And, you know, when we talk about processing times, we're talking about 2.5 years before you have your green card. You know, so still the best way to get into the US. And I think some of the bad actors that we've had in EB-5, they're going to have to disappear. I think at the 800 level, plus the security and integrity measures put in by the legislation, it's going to be too hard and too expensive for a bad actor to get in. I think it's going to be more institutional level projects like 1900 Broadway with fixed construction budgets, fixed development timelines, and more transparency for investors.
Good.
Yeah, I want to be clear that, like, look, we saw the bill, right? Did we get everything we wanted? No, we didn't get everything we wanted, but do we have something that we can work with? I think that's certainly the case. And despite some of the reports going out there and everything else, I still think that we have a workable program, right? So it's still going to be essentially for all you people with families overseas, right? It's still going to be one of the few practical ways that can really help your entire family immigrate to the US. So, I mean, we'll figure it out like we always do, but I think there might be initial slowdown during the 60 days, obviously, but I think as it goes, we'll figure out what to do with it. And I think we still have a viable program.
Yeah, I completely agree with what Nima and Fung have said so far. And, at the end of the day, we have a program. USCIS is going to start processing cases again. They are going to start issuing I-526 approvals, conditional green cards, combo cards, and permanent 10-year green cards. So it's been a long wait, and things may take a little bit longer just to ramp up and get up to speed, but it's there. And so for everyone who's been waiting for so long, you are going to get all of these benefits that you originally sought to get. And I think that's definitely a plus.
Yeah, no, agreed. And we thank you guys. And we'll just take one last chance here, just reminding everybody about our 1900 Broadway project and also talking about our legacy fund. And in our next event, we're going to talk more about the investment particulars. What's life coming out of COVID? Where is the development world? Interest rates, inflation, how does it all play? Where do you want to be during the next era of EB-5? And that's for existing investors and new ones. We're all going to be in this together. Even if you've already filed, that means the investments are still going. So, we are positioned here for the next cycle and the next, group of era of investment where we've put the tools in play, and the things that we're doing with our multifamily apartment projects, our construction-based job creation, we still check every box that EB-5 has in the new bill. So when you talk about changes in the investment amounts, you talk about changes in the job creation, any of the integrity measures, we still check every box. And we are extremely lucky to have a mature project where it's already under construction and already going, and essentially tipped and ready to go, full documents. And we're going to be talking about it in detail, as well as the 3 investment options that we have curated over the last couple of years. Low risk, low return stuff with the max protection and debt style investments, all the way up to common equity. Essentially, we're able to create bespoke investments based on your own needs. And then the opportunities for the Unity lender, and essentially moving forward into the next phase of EB-5. So that'll be our next webinar. We're expecting to do it next week. We're just updating every single document and updating all of the numbers. We'll have updates on all of the fee items from USCIS and the changes expected there. And even though USCIS has openly stated they're not planning on accepting I-526s for a period of 60 days, it's being discussed right now with the State Department if they will hold the petitions in abeyance, and they'll take them early but hold on to them. Either way, we are moving forward and filing subscriptions and moving into the next phase of EB-5. There are not that many spaces left in this project because it's been going for a number of years already. And again, the construction has already started. There is really a race for the EB-5 to be filled before all the job creation is complete. And that is taking place right now. And I'll just show you a screenshot of the live camera of 1900 Broadway right now. So on its 3rd floor, and expecting to deliver in the middle of 2023, just 18 months from now. And, post-COVID, after everything is on its way to recovery, full job creation in swing. This is about as mature as an EB-5 project can get, right before you almost call it too late. So we'll be talking about this in detail starting next week. So, again, we want to thank everybody for joining us today. Obviously, we're all extremely happy to really have a new bill and have an opportunity to progress and move forward. They got the grandfathering figured out. We don't have to worry about something really, really bad happening. It never made sense from the beginning, which is why it led to the second lawsuit. Congress got their act together and didn't make us actually go to court, even though there were times where I felt like we would have been happier in front of a judge instead of 60 senators. But either way, again, thank everybody for their support over the last 8 months. It's been really difficult, and we're all looking forward to putting it behind us and never having to talk about it again. And that goes for the existing teams that we have, as well as our future partners. As long as they're filing before the end of September in 2026, everybody will be grandfathered forever, and that's good news. So I want to thank everybody, and then if there's any closing thoughts from anybody else, but thank you to the KLD team and our team here at Behring as well.
Thanks, Colin. Thanks, guys.
Thanks, guys. Appreciate it.
Thank you.
Yeah, I guess last item, anybody that's looking to schedule private calls or wants a consultation with the team to discuss EB-5 or the projects, in the bottom left-hand side of the screen, there's a scheduling button for the find a time. You can make appointments just by clicking there and clicking a date that works for you. I look forward to talking to everybody over the next coming week or two. So again, thank you, everyone, and good luck with everything else going on.
Thank you.
Thank you, everyone.
Thanks, guys.